I do have skills that make me a nightmare for people like you.
G'day guys. Well, I don't know if you caught up with the last recital of the transcript from the 7th of November or not. If not, I highly recommend you do that first before watching this one. Now, given, and there's been quite some discussion, and you'll probably see those in following parts, between myself, the criminal manager of Auckland District Court, Jackson Cutting, and Chris Hurd, who is the senior solicitor of Ministry of Justice, well, one of them. So what's I've been told, and this is in regards to the lost trial, to the 9th of February trial that we had. It was there from 9:30 in the morning till about 4:30 in the afternoon, and of which about 5 or so odd hours of which was trial time, you know, off and on, as it does become quite sporadic during the day. So yeah, after an investigation, as Jackson might put it, they've looked into the matter and found out that it's human error. They've said that any registrar or officer of the court is immune due to error or omission, although I would put it to you that if it was confirmed on the 9th of February that the recording system was in operation and verified there and then, there is no error or omission because it had already been confirmed otherwise. So what I did sort of mid-March, a few weeks back, is I actually went in on the 15th of March with a friend of mine just as a witness, and I wanted to inquire about the complete case file. I wanted a copy of the complete case file to date, and given it was the 15th of March, anything prior to the 15th of March, 28th. Now, I don't expect the transcript, that wasn't supplied to me until the 23rd of March, but on the 15th of March I would have expected everything to have been in the case file. Now, it's one thing to say that it's human error for, you know, someone not pushing a record button, and then of course not supplying the details of that person for me to have any sort of reverse liability, because as far as they're concerned, that he's immune. And you know, I'm not after any one particular person. I just want to see whatever the errors were get fixed so it doesn't happen again. So it's one thing to say that the court recording was lost due to error, omission, human fault, whatever. But just today, it's the 28th of April, just today I decided to go through that large wad, and it was quite the wad, of a case file for this $80 ticket that Auckland District Court supplied to me on the 15th, and when they brought it to me on the 15th of March, we waited there for near on an hour. When we were hollered at by Rita, hanging out of a door on the other side of the foyer there, we went over and we were given the opportunity, or I was, my witness just stood there, but given the opportunity to make sure both files matched. And I went through one file and then I put them through the other, and I made sure that they were matching files. I didn't inspect every page obviously, but I just skimmed through to make sure that what was in one was the same in the other. Now today I decided, you know, just to sort out my paperwork basically, and to try and chronologicalize, you know, everything that was in that file that they gave me to make sure things were in order. Although I remember having about 23 separate emails to Auckland District Court prior to the 13th of July, there's only 3. The interesting thing that I found is that there's no transcripts in the case file. There's no transcript from the 7th of November. There's no transcript from the 13th of July. They aren't there. None of the submissions that I filed to the court just after the 13th of July are there. None of my motions to dismiss were there that I could see from back in October that I filed, although I may be slightly wrong there. But I'm damn sure what wasn't in that complete case file was anything to do with the 9th of February. Now, we're not talking about just a lost audio recording that can't be transcribed and I can't have a written record. We're talking about the 6 separate exhibits that the prosecution's witness entered into evidence. These are physical documents. We're talking about that. There were exhibit 1 through 6 weren't there. I filed a report on the 9th of February. All of the emails that I brought in on the 9th of February to substantiate my claim that I had been responded to through automatic response for the 4 separate requests for documents, none of that was in there. Just the one email response that I had supplied from back in the 7th of November. So any paperwork of the 42 or 44 page document DUT 244, the Speed Camera Operators Module 2001, that was entered in, but it wasn't there. Nothing I entered on the 9th, or nothing that the prosecution entered on the 9th physically in paperwork, none of that was entered in the file. It's not like they just lost the audio recording of the trial. They lost everything, or did they? Where is it? Because they've got all the other shit in there, but there's no 9th of February filings whatsoever. There's the judge's notes, where there's the 9th of February, a few notes marked there about, you know, when we're supposed to respond and when the prosecutor responds, you know, that time frame we set up at the end of the 9th hearing. But there's absolutely nothing in the lines of any submissions. Why is that? Why have they not just lost the audio recording? Why have they destroyed any fucking factual evidence whatsoever of the fact that the 9th of February hearing ever happened, other than the judge's notes? Now, it's fair enough for them all to admit that they lost the recording, but what the hell happened to the somewhat 50 pages of documents that should have been in the complete case file on the 15th of March, 6 weeks afterwards, when I went in there to get a complete copy? Where'd they go? Anyway, that's food for thought. What I'm going to do now is, this is the court transcript from the 28th of February at 10:41. Ironically 10:41, and the 7th of November was 10:42 that it started, so just one minute out. Weird. This is in the Auckland District Court, between New Zealand Police and yours truly. The hearing date, like I said, 28th of February 2018. The appearances were Kate Blackmore, or Kay Blackmore, for the prosecutor. The defendant again appears inside my person, supported by R. Chambers as amicus curiae. No, I fucking wasn't. And in fact, in this transcript, I mention just what he tried to do. It's also going to be mentioned in following parts as well, but I would hardly trying to compel the defendant to be a witness. You know, it's called the section 25D, I believe it is, of the New Zealand Bill of Rights, where you cannot be compelled to confess or give testimony. All he did was try to get me to confess. He kept asking time and time again, Was I there? Was I the driver? Trying to get me to make some statement. So clearly R. Chambers was not supporting me. He was there, as we've said before, to have his first duty to the court and to try and get this sorted out and get rid of him. We don't want him in our courtroom. So, well, here it is, legal discussion before Judge Nicola Mathis. Mr. Keane, yes, Miss Blackmore. Mr. Keane, I think I have an application again to record the video of the proceedings. I have one here if you need it. I've seen that, thank you. It was most unfortunate that when the matter came before me earlier in the year, that even though I had asked for the register, the court taker, to make sure that the proceedings were being recorded, that they were not. I have again today confirmed, well, I have had confirmed to me by both the court taker and a senior registrar that what is being said is being recorded, and I have had, I think there is an email confirmation from the transcribers who are listening in and can confirm. You can't see them, but they can go into the system and they can confirm that everything is being recorded. Thank you. Normally, as you are aware, this discussion would not be transcribed, but I know that you want that, and I will make that available to you, but I am not going to allow you to record or video. No harm in asking, Your Honour. Thank you. All right. Thank you. So, I have read your submissions. Yes. I haven't heard from the prosecution, and I am just dealing with the situation as to the way forward from here, as to whether I should or should not dismiss the case at this stage because of what has occurred, or whether I should set the matter down for another hearing. I have been told that the matter cannot proceed before me until probably July. So I have read your submissions, which relate to the slightly different matters. So is there anything that you want to say as to why or why not the charge should be dismissed at this stage? Other than just reiterating what's in my motions in regards to the many failures in disclosure and procedure that have happened in this case, there is also the missing court transcript. I mean, I've actually, through an Official Information Act request, obtained the latest speed camera operator's manual, and looking through that compared to what the witness said on the stand, there are some clear errors in his testimony to what's actually in this manual. It's pretty much just a copy of the other one that I've already submitted. It's just slightly worded differently with the... So, what date was that? This is the 2015 version. I have a copy here for the court if you'd like it. Thank you. And you had asked for that to be disclosed, or you had obtained that separately? I obtained that through an Official Information Act request. No, the earlier one. Oh, I was. That was just supplied to me through the legal counsel at Waitemata Community Law Centre. Okay, so did it come through the prosecution? No, I obtained that individually. I would also bring to your attention that on the 7th of November you stated in the transcript that what would convince you that there had been a miscarriage of justice was not the mere issue of the provisions missing from the charging document, but also the copies that I supplied last time, of which I have another copy here, of the 4 separate occasions where I asked for all of that information. I think I've already got those, so I don't need them again. Thank you. Yes. So you asked for those, which I'd already supplied as well. Furthermore, you had given a Section 30 disclosure order to the prosecution to supply me by the 14th of November everything. Upon reading the transcript from the 7th of November, I recognised that there was also a report that Sergeant McMurtry was referring to. It was only after reading that and asking that that report was then supplied to me in January, 2 months after I should have had it. So that yet again another failure. The amicus curiae appears to continually compel me to say whether I was driving. Oh well, I don't need to go there, that's fine. Well, it's a breach of my Bill of Rights, Section 25C and D. It's, to me, related. That's fine. Yeah, so you know, given the multiple errors in this case, It's now been 4 trips. I shudder to think how much resources have been spent for an $80 speeding ticket. On a speeding fine? Speeding ticket, yes. Yeah, so the witness couldn't identify me as the driver that day. He couldn't identify me in the photo. He couldn't supply evidence of the 80k temporary speed zone he mentioned his employer. I'm not going into that aspect of it at this stage. Okay, they're all relevant to me and in the bundle. So yeah, given the multiple errors, I'd consider this a miscarriage of justice, and I ask the court to find the same, and also require costs in the Criminal Cases Act section 7.5. I think it is for costs for my now 4 trips and over 150 hours I've spent studying. I'd also like to add that I found out where it went wrong and why the provisions weren't on the charging document. That's due to myself requesting a court hearing as soon as I got the initial ticket. The initial ticket does not have the provisions on it, and that would have been why they would not transfer it over. So I've let the Minister of Police know that one too. Thank you. Thank you, Mr. Keane. Thank you. Mr. Chambers, do you want to say anything?
Not really, ma'am. Except to say that I think we've reached a point in this matter where there needs to be some pragmatism. I appreciate that it's a matter that concerns an infringement fee, and the costs at time and things like that. I, in fact, have some sympathy for the defendant's position. I do.
Ms. Blackmore? Yes, ma'am. I understand why Your Honour would be unable to proceed to making a decision on the basis of your notes made at the time, particularly the circumstances where the defendant has put the issue before the court as to the transcript, and it's most unsatisfactory that there wasn't a recording, though that, due to not the prosecution's fault or Mr. Keane's fault, it's one of those systematic, perhaps, errors. No, and yes, ma'am, and in that circumstance, given a re-hearing is indicated by Your Honour as being necessary, but for my friend's dismissal application, I consider that the public interest test under the prosecution guidelines would not be met by proceeding with this matter. However, there is as obvious the issue as to the costs claimed by the defendant, and that was strongly opposed by the police. And if Your Honour is considering an application, I consider there would need to be some submissions filed, because there appear to be considerations as to disclosure at the forefront, and the police don't accept my friend or the defendant's submissions on that. I think that's somewhat of a side issue in any event, but in terms of the Costs in Criminal Cases Act, there does not seem to be a presumption either way as to whether there's a dismissal or withdrawal of the charge as to what the court finds. But in my submissions, there were a strong evidential foundation for the infringement offence, and that's clear on the law that would have been placed before Your Honour had we proceeded. And I think you've already been referred to section 133 and 145, but I think we need to address the issue of costs. Costs? All right. So, can I deal with it on this basis that the charge is dismissed by consent? Yes, ma'am. I seek leave to withdraw, but I'm happy if you wish to dismiss it. I think it has been dismissed because it's, well, you can't relay it. Yes. No, ma'am.
Your Honour, could I just add, under section 133 it says that the registered owner or owners are liable. I would point out that the liable only means upon conviction, and I still maintain the presumption of innocence until the evidence proves that.
Sure, that's...
I've also spoken to Jackson Cutting this morning in regards to the missing recordings as well, and he's looking into that for me.
Thank you.
Thank you.
So I think that's a very pragmatic, very sensible attitude to take, Miss Blackmore, in this circumstances. The charge will be dismissed by consent. I will reserve the question of costs, Mr. Keane. You have given me, I think, as much as you want to give me in respect of costs.
Yeah, if not the time I've spent studying, certainly the 4 appearances and petrol and parking, I'm out of pocket.
Sure. I will give the prosecution the opportunity to file some written submissions in relation to costs.
Sure.
How long do you want, Miss Blackmore?
I see 3 weeks, ma'am.
And do you want to reply? I think it would probably be sensible to give you an opportunity to.
Certainly wouldn't hurt. Sure, thank you.
It'll just be on the papers, so the 21st of March for the prosecution.
Thank you, ma'am.
Mr. Keane, how long would you like after that?
Same would be fine, thanks. 3 weeks.
3 weeks. I know Easter will fall during that period.
After Easter will be fine then.
Do we say the 11th of April?
That'll be fine, Your Honour. Thank you.
Mr. Chambers, I don't think I need to hear from you unless you want to be involved.
Well, no. I'm happy to stay with it in the meantime, so long as I can get copies of the papers and what have you, because
if there's anything that you want to add, perhaps you could do that by the 11th of April as well.
yes, I can, yes, thank you.
So, if Mr. Chambers can be kept in the loop.
I'll keep him in the loop, Your Honour.
So, the charge itself is gone, Mr. Keane.
Thank you, Your Honour.
But I'll hear about the costs, as I said. So, for the prosecution to file and serve submissions by the 21st of March, and for you to respond by the 11th of April, and Mr. Chambers by the 11th April as well.
Thank you very much.
Thank you, ma'am.
Thank you, ma'am.
It's been emotional.